Hello and welcome to Uncommon Law, my podcast about true stories from my life experience of over 50 years as a lawyer and trial judge. This is a look at the law from the inside out, stuff they don't teach in law school. This is Judge Rudy Greco, retired justice of the New York State Supreme Court. A buddy of mine, Ronnie Rubenstein, was a prominent criminal lawyer, defense lawyer, really good one too. Ronnie was a swell guy. He had a client who was a gambler, a bookmaker and a gambler. And the client was the plaintiff in a wrongful death case. And the gambler himself was a rather ordinary guy. He was a homeowner in the suburbs in Nassau County. And he was pretty much like everybody else, except for the fact that he was, a bookmaker and a gambler. But he was pretty ordinary. He had a family. And tragically, the case was simple. It was tragically simple because it involved his 11-year-old son who was riding on a bike and was instantaneously killed in traffic on a busy street in Nassau County. These things are all too common in the metropolitan area. It's so crowded and you have so many kids and bikes and traffic. Unfortunately, these things are a little more common than we think. Well, anyway, the case was marked no pay by the insurance carriers who were defending the case. And the insurance carriers, their whole modus operandi is very transparent. Everybody in law knows all about it. Their whole idea, their mantra is to pay as little and as late as possible. If they offer you or a client a deep discount, it's because you probably have good liability and they're trying to get you to short yourself on value. And what they have going for them is that cases are drawn out and they use every tactic possible to delay and deny until the time comes to pay. They live off the interest on unpaid claims. They have money set aside to pay claims. There's money's undeposited in banks and it earns interest. And that nightly interest on unpaid claims is termed the float. And that float is a major integral part of the whole business of running insurance companies and insurance carriers. And so they just wait you out and they try to exhaust you in a battle of attrition by stalling. And hopefully you're going to lose your patience. Well, in New York State, more than 90% of the cases that reach the trial stage will settle. And they usually settle in the last minutes when you're selecting a jury, during the trial, sometimes even when juries are out deliberating after the trial, the case is settled because there's a very frantic, high-pressure atmosphere that comes to play. Plaintiffs are uncertain about the outcome. You may not know, you may not feel strongly about what the jury might do. It's unpredictable. The defense lawyers feel the same way. If they feel that they've got a bad case and the jury has been on the plaintiff's side, they'll try to cut their losses by offering you money that would be less than what the jury would possibly award you. Everybody's got a game going, and the judge himself very often is under pressure to get dispositions from the Office of Court Administration. Some judges will produce more work than others, and sometimes judges are under pressure, like, let's get going and get rid of some of these cases, whether you settle them, try them, or whatever you do. In any event, the whole thing about litigation is the national sport. Forget baseball, football, boxing, hockey, basketball, or anything else, tennis. Litigation and the money that goes back and forth in litigation dwarfs all of those sports' income and net proceeds put together. And so it's a very high-pressure proposition. So this was a wrongful death case, which means that the person died almost instantaneously, suddenly, and as opposed to a case where somebody gets hurt and they have pain and suffering. And in wrongful death cases, the measure of damages is very simple. How do you measure the damages? It's basic economic loss. Pain and suffering aspect, which could run into big bucks in front of a jury, is not present. It doesn't apply to wrongful death because the person didn't live. They got hit. They didn't know what hit them. So there was no pain and suffering. They just lost their lives immediately. On the other hand, trying to figure out in wrongful death cases what the damages were depends on the age and the occupation of the victim. So, very young children, how do you figure basic economic loss for a very young child when you don't know if that child is going to end up to be a homeless person sleeping on a park bench or a CEO of a large corporation or a movie star for that matter? You don't know. So, those things are up for grabs. It's very tenuous. On the other hand, if the person is very old, they're a poor case or a poor case for heavy damages because they have a very, very limited lifetime. And maybe they're on a fixed income with Social Security or anything else. Or if they're at the end of their career, even if they make big money, it's only a couple of years. And actuarial witnesses will come in and testify as to what their earnings could be and how long they can expect to keep earning money. So it's a matter of just adding up years and earning power. So this was not an ideal case because, unfortunately, this was a youngster, and we couldn't determine his real earning capacity. I mean, the ideal wrongful death case would be a relatively young person, let's say in their 30s, who's a doctor or a big shot in digital industry or anything like that, and where you could see and they have established earnings and you knew they have a long time to live. Those are the ideal cases. This was not ideal. And another reason, even more important, of why this case was not ideal was probably the reason why I got the case in the first place. There's a very, very serious problem in that this case was one of the last surviving cases under the old rule of law called contributory negligence. Under that rule, if a plaintiff in a lawsuit was found even 1% negligent, they were barred from getting a verdict. They couldn't collect on a verdict. That rule was promulgated by the insurance lobby. In New York State and other states, I'm sure it's the same thing. You have two powerful lobbies that are always jockeying for position and with the legislature and to get new laws that favor their one side or the other. One of them is the trial lawyers who want very lax and open laws, and the other one is the insurance lobby. Both of them have very, very powerful lobbies. And the insurance lobby, years ago, got contributory negligence passed and held up until, after decades, public opinion just overwhelmed the legislature and they had to change the law, much to the chagrin of the insurance companies. Well, anyway, this was a contributory negligence case. Even though now, when the case was tried, we were operating under the law of comparative negligence, which is a different ballgame, which is the standard now that most states, even now, I think if not all states, and the federal government uses. Comparative negligence just says, let's find out how negligent, if at all, both parties were, totaling 100%. So if a plaintiff was, let's say, for example, 50% negligent, well, when the verdict came, and let's say the verdict was $1 million. Well, if the plaintiff was found and the jury found them to be 50% negligent, they would cut the award to $500,000. So the award would be discounted by 50%. That's comparative negligence, and that's a fairer standard, rather than disqualifying somebody who was just one iota, maybe 1% negligent from collecting at all. So this case was, once again, an old rule contributory negligence case, which is probably why a young lawyer like myself got to try it. More experienced lawyers wouldn't want to be bothered. It was too risky for time and effort, especially on a contingency basis where if you lost the case, you weren't going to get paid. And in any event, what made it also a little more difficult was the case, and the accident itself took place, and the case was to be tried in Nassau County. Well, Nassau County is right next to New York City. But Nassau County is filled with mostly middle class or upper middle class even homeowners who have mortgages. And they pay insurance and they don't want their rates going up. On the other hand, in New York City, it's a more favorable atmosphere for plaintiffs because we have very rich people and very poor people. The very rich people think in big numbers, which is very good. The very poor people view litigation and lawsuits as litigation lotto and a chance to get even with the system. So they make big, big awards. And New York, the streets may be mean here in New York, but I love it because while the streets may be mean, the juries are very kind, as opposed to Nassau County or other places outside, anywhere else in the country, outside of California, perhaps. Well, we had a pretrial conference, and the judge, who was a very nice man, he managed to wangle or pressured the insurance company into offering something on the case. It was no pay, but they offered $7,500, which was back in the 1970s. It was nuisance value. Now, it's nuisance value. What's the loss of an 11-year-old child? It's got to be worth a lot more than $7,500. But apparently, the insurance company knew something that I didn't know entirely. So we go along, and I had to explain the offer and the paucity, the low number that the insurance carriers were offering to the father who lost his son. So I called him to my office for a meeting, a little conference, and I explained. And I was very, very tentative about explaining because how do you explain how little the insurance carriers thought of his 11-year-old son's life to a person? Well, this guy looked at me and he said, "Don't worry about it. Roll the dice. I'm a gambler. Let's see what happens." I was stunned. I didn't show it, but this was a new low. I never expected that reaction. This guy lost his child, and he was looking at this like a gamble. And all I could remember, I started getting nauseous, and all I could remember was I had this dead child's photo in front of me, and I looked at that rather than looked at the father and engaged in looking at his cold response. It was really a new low for me in human relations. In any event, the case went on and finally came to trial. My adversary was reputedly the best defense lawyer for the insurance carriers in Nassau County. He was also the president of the Nassau County Bar Association, which in Nassau County, which was a very clubby atmosphere to begin with, that was pretty important. So for me, it was, I did a lot of criminal defense work, it was just another away game, just like all the criminal trials were. Here I am, and I'm against the locals, and the locals all know one another, and okay, it's an uphill battle. In any event, the judge was a big, huge guy who had been a college football tackle, and a very good one, by the way. He was also had been a town mayor of a very, very large town in Nassau County, and he was also an ex-member of Congress. He was a big, warm guy, and it turns out he was a Brooklyn boy like myself, so that wasn't bad, and this was his first Supreme Court trial. He was friendly, which was nice because my adversary was arrogant and needlessly so. Apparently, these guys are very successful. And when some trial lawyers, a lot of them get arrogant when they're successful, and they start even to go beyond arrogance to the point where they're bullies. And these guys were trying to bully me. I was young, and this guy was trying to bully me. But I come from South Brooklyn, and where fighting was a religion, a way of life, and bullies were very, very familiar and easy meat for me. I didn't mind at all, so no big deal. And the judge, being a Brooklyn guy, I think we had an unspoken code. He gave me a lot of room to fight back, and I sensed it, and that was pretty good. That helped. So that offset some of the negative factors that I was up against. Well, the trial went on, and it proceeded for a week. And the whole week, in the first 4 days, they put on witnesses, and their witnesses really couldn't do too much to me, especially on the last day. Their witnesses were not harmful. They were matter of fact sort of stuff. I had cross-examined the defendant, the driver of the car that killed the little boy. And the driver of the car that killed the little boy was an 18-year-old kid. He was a student. He was a saddened by this experience. It was terrible. And I went very, very easy on that young man because obviously he wasn't reckless or anything like that. It wasn't that high speed kind of a thing where you could put some blame on him. And I kept basically leaning on the idea that maybe he was distracted. Maybe he was turned on the radio and he lost sight of the kid for a moment, or he dropped his glasses. I kept fishing for something, but it didn't happen. But I didn't abuse the kid and make him a sympathetic figure. I actually felt sorry for him because it was a tragedy for him too. In any event, I then rested my case. The defense put on witnesses, and their Friday witnesses were all matter-of-fact technical stuff, and they did me no harm. But the defense lawyer was now crying. The tide had turned in my favor at this point in time, and he was crying, "This is going to be $1 million verdict, and we're going to have a mistrial here. This is... I don't understand how this is happening." And he was whining and everything else. Anyway, the judge, we called off the trial for that day and to resume on the following Monday. Well, the Monday comes, and the judge asks the defense counsel, "Do you have any further witnesses?" And he said, "Just one more, Judge. Just one more witness. I want to swear this witness in." Okay, and they called this woman. And the woman they called to the stand was about 45 years old, a blonde, and very attractive, nice-looking gal. And she supposedly had a Las Vegas, Nevada address, which she gave from the stand. And apparently they brought her in from Las Vegas. Now she starts to testify. Turns out she's an eyewitness. She said, "I lived near the place of the accident, and I was shopping, and I went to this strip mall, which was a whole block long of one-story commercial stores, which was dissected in the middle by a driveway, which led from the busy street back to a parking lot, which was behind both halves of the storefronts." She said, "I was parked immediately facing the driveway. I was the first car facing adjacent to the driveway. So I saw everything that happened." And I remember her testimony almost word by word. She said, "This young boy came out of the driveway on his bicycle like a rocket ship into the main street right in front of my car. That driver never had a chance. Boom. There goes my case. It's over. The die has been cast," if you want to put it in gambling terms. Contributory negligence, we're not getting anything. I lost the case. The judge called me into his chambers after the case was over. I got a weak handshake from the defense lawyer. It was really a weak handshake, like a fish. And they were relieved to get out of there. And the judge called me in, and there was another judge in chambers. And my trial judge, by the way, was his first Supreme Court trial, I found out later, tells the other judge, who himself had been a mayor of another Nassau city, "Andy, you had to see this kid from Brooklyn. This kid was terrific. He threw a block on those guys. They didn't know what hit him. If he ever gets a good case, he'll come back here and make a fortune." And he shook my hand, which was small consolation. Well, the boy's father, upon hearing the verdict, was unmoved. To him, it was just another gambling loss. You win some, you lose some. Thanks for listening. Come back next week for another episode of Uncommon Law, lessons they don't teach in law school. I'm Judge Rudy Greco. Court is adjourned.